good afternoon to everyone who is listening to us. Today we are very honored to have with us Professor Mrs. Jelena Aparac. Let me introduce Mrs. Jelena Aparac. She holds a PhD in International Public Law, and her dissertation focused on a very interesting topic. It is international criminal liability of corporates for international crimes committed in non-international arms conflicts. She also has LLM from the Geneva Academy of International Humanitarian Law and Human Rights Law, and she is also a lecturer in international humanitarian law, human rights, international criminal law, and international refugee law. She has given many conferences and academic institutions, and she also has a very strong background in the field where she works. She has also participated in drafting several complaints against corporations and worked as a consultant on refugee protection, humanitarian action, and diplomacy, protection of civilians and medical missions in armed conflicts. And as a field worker and legal advisor for Médecins Sans Frontières, Mrs. Aparac worked in conflict areas such as South Sudan, Chad, Darfur, the Democratic Republic of the Congo, and the Central African Republic. And of course, currently, she is an independent expert for the UN Working Group on the use of mercenaries as a means of violating human rights and impeding the exercise of the right to self-determination. And she will bring us a very interesting topic, Professor Jelena, and now I will treat you by Jelena, if I may allow it, and it's related with the joint statement by independent United Nations human rights experts on human rights responsibility of armed non-state actors, which is from the 25th of February 2021 and was adopted in Geneva. So, Professor Jelena, you have all the floor. We are all interested to hear you, and of course then to speak a little bit with you, if you may allow. You have the floor. Many friends.
Thank you, Anabela. Well, thank you, my dear friends and colleagues. I'd like to thank also Lara, Inigo, and Anabela, yes, to you for inviting me to speak today to the first Congress of International Law of Nova School of Law. And I also would like to congratulate you on this first Congress. And I think it's very important that you organize a space for a debate, especially on the issues that are of contemporary concerns to the international law. And the reason why I've chosen this topic, I think, is because it relates to quite a lot of things that we all associate with, or quite a lot of us are concerned with, or work on, or research on. And I think it's a very important topic that we address today. And I think it's a very good topic to start your first Congress on International Law. And it's on the human rights of non-state actors, human rights or responsibility of non-state actors, sorry. In recent decades, as you know, we have seen the transformation of armed conflicts around the world. And in general, we have seen the multiplication of non-state actors in international relations. And those non-state actors, they vary in different forms. They can be armed groups, armed non-state actors, mercenaries, foreign fighters. They can be called foreign terrorist fighters. They can be also multinational corporations that are involved in armed conflicts or international action, such as, for example, private military and security companies. And all these actors can, and effectively they do, commit human rights abuses. And yet the state-centric approach to international law today, and in particular to human rights law, can create significant obstacles to their responsibility because, as you know, we consider that states are the subjects of international law, and they are the main responsible for respecting and ensuring the respect of human rights, even when human rights abuses are committed by private actors and non-state actors. And in this context, group of several UN experts have issued on the 25th February this year, 2021, a document that is called the Joint Statement by Independent United Nations Human Rights Experts on Human Rights Responsibilities of armed non-state actors. And it is a statement issued by a group of independent United Nations experts, as the title says, and its objective is to highlight the far-reaching negative human rights impact of armed non-state actors on rights holders and human rights defenders. And this is the very first statement of this kind that takes a public institutional positioning on this issue of non-state actors and human rights. And it's very significant in this regard. Lots of different experts within the UN system have had their statements or reports or public speaking on the responsibilities of non-state actors on human rights. But this is the first joint statement of several experts, and it's institutional positioning. And I think in this sense, it's very, very relevant. With this statement, the experts consider that the existing international legal protection, in order to be effectively safeguarding human rights of individuals and groups, should not consider the status or character of the perpetrator. Any actor who de facto controls the territory or the population or exercise government-like functions should ensure the protection of human rights. And in this sense, it joins the legal logic of humanitarian law. And in addition, experts believe that victims must be in a position to seek redress for violations of abuses of their rights, regardless of the actor who is at the origin of their grievances. In order to ensure that human rights of individuals and groups are respected, protected, and fulfilled, irrespective of the character of the perpetrator, the experts formulated their recommendations to the governments, but also to armed non-state groups and other actors, including academics, but also corporations. I am the chair of the UN Working Group on the Use of Mercenaries, and in this capacity, I was involved in the name of the Working Group on the Use of Mercenaries in the drafting of this statement and in the process of it. And I am very happy to see the statement seeing the light today. Let me now say a little bit on the Working Group on the Use of Mercenaries and how we, from our perspective, see the non-state actors and human rights and their obligations to human rights, and why we were involved in this statement in the first place, and we endorsed it. The Working Group on the Use of Mercenaries is part of the special procedure under the Human Rights branch of the UN. And we have the explicit mandate to monitor and study the effects of mercenaries and mercenary-related actors, but also private military and security companies, so-called the PMCs, on the enjoyment of human rights. In our mandate resolution 42/9, the Human Rights Council recognized that the mercenary activity is a complex crime in which criminal responsibility falls upon those who have recruited, employed, trained, and financed the mercenary, and upon those who have planned and ordered their criminal activity. The working group has been extremely active in pursuing the implementation of its mandate through its normative advocacy work to both prevent and ensure accountability for human rights violations committed by mercenaries and PMC personnel. And in some instances, when the actors don't fit necessarily both definition, they could fall within mercenary-related activity. How do we concretely do it? Well, we submit thematic reports, concretely 2 thematic reports per year, one to the Human Rights Council, usually in September, and the other one to the General Assembly, usually around October, in regards to mercenary and PMCs and their impact on human rights. The necessity to further contribute and to advance international debate on the legal and normative development has consistently been the priority of the working group. For example, in our report on phenomenon of foreign fighters and the possible linkages between foreign fighters and mercenarism from August 2015, the working group noted, and I quote from the report, "As it's the case with all other members of state armed forces or non-state armed groups, foreign fighters are at minimum bound by the peremptory norms of international law. When committed as part of a widespread or systematic attack directed against any civilian population, with knowledge of that attack, those acts constitute a crime against humanity. In addition, non-state armed groups that exercise effective control over territory, such as ISIL, are increasingly considered to be bound by international human rights obligations in relation to all people within that territory." In 2017, in the case of increasing use of privatized detention, the working group noted that, and I quote again, "Although the state ultimately has the obligation to respect, protect, and promote the realization of human rights, there has also been a growing support and acceptance by the international community of the principle that non-state actors, including business entities, must respect international human rights standards and obligations. The responsibility of corporations to respect human rights in their operations and business relationship is now a widely accepted concept." End quote. When it comes to corporate actors, the working group has also studied a specific relationship between two categories of corporations: extractive industry on one side and PMCs, private military and security companies, on the other side, and how their impact on human rights. And as it's recognized, the private military or security company and its personnel providing services to an extractive company in a situation of armed conflict is bound by the rules set out under international humanitarian law and should respect human rights. More recently, in the report addressing the role of PMCs in migration and border management, which is very often outside of the armed conflicts and a context that is not sufficiently explored in terms of the role of the PMCs in general, the working group has noted, and I quote again, "The international human rights framework sets out clear obligations for states to respect, protect, and fulfill the human rights of all people, including migrants, under their jurisdiction, and responsibilities for companies to respect these rights. The mandate holders further noted that given the heightened risk of gross human rights abuses associated with the provision of private military and security services in migration and border management, companies in this sector should pay particular attention to the human rights risks that their businesses and their business activities and relationship may pose, particularly to individuals or groups in vulnerable situations." In addition, the working group has consistently called on companies to exercise heightened human rights due diligence and has urged companies to be more transparent by publicly disclosing accessible, clear, and non-ambiguous information with regards to their contracts and operations, as well as adverse human rights impacts by their operations. Just recently, in April 2021, in my expert statement at the second session of the open-ended intergovernmental working group to elaborate the content of an international regulatory framework without prejudicing the nature thereof relating to the activities of private military and security companies, that's the full name of the intergovernmental working group, I have invited states to also consider to include explicit provisions to the future potentially binding treaty where PMC services have negative impact on the environment and on the rights of people to self-determination. In addition to those thematic reports and interventions, we can also address corporate human rights abuses and responsibility through the process of what's known communication system under the special procedures. So any individual, community, or a group of people with information on alleged human rights abuses by mercenaries or PMCs could submit information to the working group. It is one of the most important tools to address the corporate human rights responsibility and the only one today at the international level. And I regret to say that, unfortunately, the procedure is insufficiently known to the wider audience, and we believe that civil society groups should find ways to use this procedure more extensively. We have received and taken action on specific allegations of violations of international humanitarian law and abuses of international human rights law arising from activities of PMCs with concerned governments, but also with companies themselves. For instance, in the cases of migrant detention in Nauru, the USA, or in Serbia, these communications were sent to all concerned actors, states, but also to private security companies as well. More recently, we have acted on the situation in Central African Republic and addressed the allegation letters to Loba Invest, which is an extractive company Russian-owned but registered in Central African Republic. In these communications, we reiterate private companies' obligations to respect human rights and embed that respect in their daily operations. Their commitment to respect human rights take many forms, including human rights training of security personnel, refusing disproportionate use of force, following non-discrimination policies, etc. I will conclude my statement with observations on two issues. First, throughout our reports, it becomes very apparent that companies have the responsibility and obligations to respect human rights, in particular when exercising inherent state functions. And this is one of the reasons why we believe that it was very important to contribute to the joint statement and bring our mandate and our experience and our point of view into the joint statement and to reinforce the statement. The second observation that I have is that this interconnection between various non-state actors, for example, between companies, for example, private military and security companies and armed groups, or extractive industry and PMCs, so two multinational corporations operating together, increase the risk of human rights abuses, while at the same time, companies enjoy a total impunity. And it's very much linked to the international law structure and how it's perceived, the subjects of its under international law. And I will end my statement here, and perhaps we can engage in a dialogue. I greatly welcome all discussions regarding the non-state actors and human rights, and I look forward to your questions and comments. Thank you. Anabela, you don't have your microphone on, I believe.
Oh, yes, I have it now. Thank you very much. It was very interesting what all the issues that you have tackled on that. And private military security companies are, and other non-state actors, of course, are a very delicate one, because when they are dealing with industrial activities, sometimes we see that private military and security companies has even assets in the firms of the governments. So when we are looking at some countries like Angola and so on and so forth, which needed, of course, investment from the outside, and they can't pay, as we say, the bills, they sometimes have assets in companies, in corporate companies related to that. And this is actually something which is sometimes very difficult to handle in human rights abuses, of course. And also, the transparency on the market is very difficult. On the national level, we have, of course, the registration. We have, of course, internal control. And I have to tell you from the Portuguese experience that I have, that previously we didn't have the regulation of the market itself. It was something which was constructed with the time. Now we have the registration of the companies, and the companies can only provide services, private services. We don't have here the possibility to provide military services if they are enshrined in the law. It is the typicity, like it's similar with the penal code. And I ask, how on earth can we, for instance, give more transparency to the market? It's the first question, because even when international organizations which want to have humanitarian relief, sometimes they don't know which is the PMC which is hiring. And if the PMC which they are hiring has a bad image, this is actually very, very dangerous to them when they go into the field. So how can we grant transparency first in the market, and who should have this jurisdiction issue? The international community only? The domestic level? Both? Which should be the fora of the dialogue in order to tackle all these issues? And I think these are at least two huge questions, which I would like to hear you, please, if possible, of course.
Yes, I mean, thank you, Anabela. These are very important questions that you're asking, and they're actually in the heart of our work that we've been trying to advocate for. In terms of the transparency, this is something that comes systematically in every single report that we work on, and it comes systematically in our recommendations within every topic that we address, be that extractive industry, be that migration, border management, migration detention. Now we have worked on the humanitarian context and PMCs, cyber security, and this is something that comes regularly. We have been calling on states to provide more transparent policies and legislations, specifically on the registration process, on the recruitment, of the training, of the vetting, licensing, both personnel, but also companies themselves. And that goes for the state. This answers your second question at the same time. Both states, the state where they operate has this responsibility once they authorize them to operate within their territory, but also the states where they have headquarters has that responsibility, including extraterritorially, when they authorize this company that's registered on their territory to operate abroad. And we have made actually a very detailed report for our last visit to Switzerland, who you know is a very important actor because it's the chair of the Montreux document, has been involved also in the Code of Conduct, has very good legislation that we found. And the Swiss legislation also concerns the extraterritorial operations of those companies registered in Switzerland. And we thought in our report that it's a very good example of the legislation that can work for the headquarter states. But of course, the states where they operate, for example, in the context of armed conflict, they also have that obligation. There is a problem here with the fact that it's an armed conflict, and it's not always easy to monitor, to oversight, to control the operations for different reasons, including for the security reasons. But it could be also the corruption. So that is something that we still need to work on. And the transparency in this case comes even more important. When we talk about transparency, it's not just the transparency of the state in terms of legislation and policies, but it's also the access to information. So even if some policy or legislations are not detailed or not transparent enough, if the victims or victims' representatives need to access some information, let's say a context where victims of human rights abuses of PMC personnel on the extractive site or victims of sexual violence committed by PMC personnel in armed conflict zone wish to bring claims to the tribunal, they do not know who they can bring claim against because they cannot pinpoint a single person in the complex relationship between different actors, meaning inside security, external security company, national security, international security relationship with the police that may be paid by the PMC or extractive company. Those relationships, even when they are legal and sometimes public, it's extremely difficult to find who would be the specific individual who would be the main responsible, giving orders or controlling the system. And for that, victims would need to access the information that are perhaps internal to the company or the contractual relationship with the state. Those information should be available to them, even outside of the proceedings. For example, in the US, we have disclosure proceeding where you need to have a process in the starting of the process in order to get some internal documents. So we are asking on states regularly to be more transparent. In terms of who could act on all this, as you know, there is no international legally binding document in regulating private military and security companies. And it's a very big gap in international law. It's a huge gap. They're not being taken into account by the humanitarian law because private security companies emerged quite late after the Geneva Conventions were adopted and additional protocols. So we, as a working group, have the mandate to work on mercenaries. And what we see is that in some instances, the personnel of PMCs could fall, and I say could fall, under the mercenary definition. But there are so many issues around it. We analyze this on a case-by-case basis. As you know, definition of mercenary is a very complex definition, and it is rather outdated. There are 7 cumulative conditions if you take Article 47 of the Additional Protocol 1, which does not apply in most of the conflicts today, which are non-international armed conflict. So there are so many issues in terms of mercenaries that if we want to address PMCs through the mercenary aspect, we very often fail to do so. So we don't have any legal regime on international level to address PMCs' human rights obligations and accountability. The working group has conducted a very extensive study on a domestic level, comparing legislations throughout different continents, taking some samples of the different states. And as you just told me before we started formally the session, the legislation that was taken into account by the working group on the Portugal is not valid anymore. So we need to update that. So we'll appreciate your inputs on that. But it's very hard to monitor all the legislations on the global level and to keep up with the changes. But it's one important aspect of regulating PMCs today, and in particular with the human rights aspect on a domestic level. The other aspect is the dialogue that is ongoing now through the Intergovernmental Working Group in its new formation. And as I said, this April we had the second session of the Intergovernmental Working Group on PMCs. It's not yet sure what would be the nature of the instrument. The states are very divided, although there is a will to go towards some kind of legally binding instrument, but that has to be determined in a later stage. Right now, discussions are more on the content of the future regime. And I think once we defined the content, the states will be able to decide whether this is too strict for them or not strict, and whether they could see it and adopt it in terms of a legally binding regime. But we are not there yet. And I think the working group has taken a very strong position on this process. And we believe that only international legally binding instrument can take into account some of the gaps that we see between one true document that addresses only PMCs in armed conflict, but not, for example, migration, border management, extractive industries in Canada within indigenous people or US and outside of the armed conflict. So we believe that there is a need for the legally binding instrument, and we certainly advocate in that sense. as I said.
Yes, that's true. It will be. I think it will be a challenge, and I won't say it is impossible, but it will be a challenge to have a legally binding instrument, because when I see to the draft of the convention, of the UN Convention on Mercenaries, one thing is to discuss power, of course, between what should be private services and what should be the state's one, because we have here also, unfortunately, business on ground. Now, this will be a challenge, in my humble opinion. And also, I want to know, really, yes, speaking in the broader sense of non-state actors, which are the sensibility of these non-state actors when we try to make a negotiations for the vulnerabilities groups, such as the elderly, the children, because some children are really used as child soldiers, and also women. How how is it possible to negotiate, which is the experience here on field on these topics, which are also very delicate from the human rights perspective?
Well, in terms of armed non-state actors or armed groups, there is one actor that's Geneva-based. It's called Geneva Call, and they have been working a lot with specifically armed groups to address their human rights obligations in the context of where they exercise de facto governmental authority or de facto control over territory and the population. And this is the work that Geneva Call has been doing a lot, and they have instruments they called deed of commitment that they see the armed groups can engage with and use that as a tool to ensure that they have some kind of responsibility on the issue of human rights towards the people that they control, or the territory that they control. This is the work of the Geneva Call, and I cannot talk about in their name, but I think the work that they are doing is really important. And Geneva Academy has been very active in that sense. And this is why Geneva Academy was also one of the drafters of the joint statement issued by the UN experts. In terms of what we see as the UN Working Group on the Use of Mercenaries, we see that very often when there is an armed conflict, former combatants, or at the end of hostilities, can either be recruited by private military and security companies to fight abroad, or in some cases we see that armed groups, actually, to avoid some kind of accountability, they transform themselves into legitimate private military and security companies that operate on the market. And they switch, they're transformed from armed groups that could potentially be criminalized under domestic regime to legitimate corporate actors doing business in the country or globally. So these are some of the phenomena that we've seen and we addressed in our report that we submitted last year on the evolving trends of mercenaries. And we've addressed it also in the cases, for example, in Syria, where we noticed that some former Syrian combatants, whether they operated for the government forces or for the armed groups in Syria, they have been recruited by different actors to operate as mercenaries by recruitment of the PMCs in the conflict in Libya, recently also in Nagorno-Karabakh, and now in our latest statement in Central African Republic as well. And I think this is something that we are also trying to address in our work. When we received the allegations, we addressed that, and these concrete situations were addressed through the allegation system, through the communications. And in some instances, we addressed it to the companies themselves when we can identify the company that recruited them. So from our mandate and our perspective, we address those actors through the allegation letters and communication system. And as I said in my statement, we also remind them that they also have human rights responsibilities.
Yes, of course. And it was a scandal when President Trump has given the pardon to the ex-Blackwater employees of the PMCs. This is always an issue also. And PMCs as corporate institutions, they can also transform, and one day they exist and another time they don't exist. They cease easily. And it is very difficult, but we should have hope, as always. I thank you very much for being here with us. Thank you very much for all the enlightenment that you have given to us. And of course, you are always very welcome. If you one day will be in Nova, we will be very glad to receive you. And many thanks, Professor Jelena Aparac. And I wish you all the best for your work. And yes, I will provide you the legal frame. It was an informal conversation. I don't know that if this day it was updated, but I will see it and I will send it, of course, very gladly to you. Okay, so
thank you. Thank you, Anabela, and thank you. And thank you for inviting me. It was a pleasure to meet you and to be here with you. Thank you.
Yes, and thank you also for Laura Inigo to put us together. This is also have a very brilliant thesis. Okay, thank you very much. So we will thank you for listening to us. And well, we will proceed with our first Congress of International Law, and we will waiting for other presentations and symposiums, of course. We have here a commentary. Let's see. Oops. Oh, here's Thais Martins, who says, perfect, thanks. So it is, it is glad to hear from our public. Okay, so I said a goodbye, and well, I will put then a previous film to end this